Hello, my name is Pierre Conac and I'm professor of company law at the University of Luxembourg. I'm teaching EU law, especially securities law, but I'm also working a lot on company law. So today I will make a presentation on modernizing the EU company law system. What you need to know. So this presentation will be around 20-25 minutes long, and we'll deal with basically two topics. One topic will be perspectives on listed companies, and the other one I will deal with is perspective for non-listed companies, since the rules at the EU level are quite different. So now let's start with some points of introduction and background, basically. So first, what you need to know is that at the EU level, company law has been quite blocked in the last 10 years, basically. So you had in the 70s, the end of the 60s, the 80s also, a lot of directives, a lot of harmonization, to limited extent. However, you had some directives. Since the year 2000, you had a lot of oppositions among member states about what are the goals of EU company law. Some member states consider that company law should be about cross-border issues at the EU level, and therefore the European legislator should not deal with anything which has not to do with cross-border issues. Other member states, like France, for instance, Italy, have a more ambitious approach and look at EU company law as a way of harmonizing national member state law. In any case, the opposition between these two types of country, basically the UK on the one side and France, Germany the other side, has led to blocking, basically, the opposition, and it made it much more difficult to adopt new regulations and directives. One victim of this opposition climate has been the Societas Privata Europea, the so-called SPE, which was proposed by the Commission, but it was a regulation and therefore it needed unanimity. So this project, which was aimed at basically harmonizing while creating a new form of company which will be able to move from one member state to the other, has basically failed due to a lot of oppositions, one of them being the treatment of employees when the company shifts from one country to the other. So in addition, regulations have to be adopted by unanimous vote, which means anybody, any member state, any of the 27 and non-28 member states can block the directive, the regulation. Directives have to be adopted by a qualified majority, so they are much more easier for the EU Commission to propose and to push through. However, still, the Commission has to come with ideas which are acceptable by member states, otherwise it's a no-starter. Because of this situation of deep opposition between member states, the Commission in 2011 asked a reflection group of experts, which I was a member actually, to make some proposals about where to go forward. So this group was called the Reflection Group on the Future of EU Company Law. This group was made of academics on the one side and also practitioners, and came from many different legal traditions. There were 13 members from North and South of Europe, East and West, Central, so it was quite diverse, and it gave a lot of input. So it was a good way to have a view about where the Commission could move forward. Many of these members were drawn from the group which is working on the European Model Company Act, which is a working group based in Aarhus in Denmark, and which tries to promote soft harmonization at the EU level through a Model Company Act. The members of this working group were acting in their personal capacity, and they produced a report in 2011, and this report, I have to say, has been quite influential and I think helpful for the Commission to move forward in the direction of EU company law. At the same time, the Commission has been also working on different issues, on different tracks, and you had, for instance, a green paper on corporate governance on financial institutions, and Remuneration Policies, which was published in June 2010. So this green paper, which is a set of ideas that the Commission tests with the public, was a direct consequence of a financial crisis. So it had to deal with the banking sector. However, you will notice that whether at the EU level or the national member state level, what is being proposed for banks or for the financial sector very often moves to the company law sector, at least for listed companies, of course, not for the smaller ones. So this is also interesting about where does EU company law go. There was also another green paper which was published in April 2011, so exactly at the same time where the reflection group report was published, and this green paper was on EU corporate governance framework. The main idea was that shareholders had pushed listed companies, especially banks, to take too much risk, and therefore they should be subject to duties or maybe subject to some constraints so that the system will be less risky. Finally, a green paper was published in March 2013 on long-term financing of the European economy, and there were also some ideas taken from the reflection group which made their way in this paper. But this paper was not just about company law. It was a general paper which dealt with many issues which were cross-sectoral. So this is a bit the background. Now back to the report of the reflection group in 2011. This report was followed by a conference in May 2011 in Brussels, where the Commission discussed the ideas in the report, and the conference was open to everybody. And then there was a consultation which started in May 2012, which is a usual way for the Commission to move forward, and where the Commission asked questions which were related to what we should do in the area of EU company law. In December 2012, the Commission published an action plan on European company law and corporate governance. This action plan was organized in different subtopics. One topic was enhancing transparency in listed companies, which means listed companies should have a better understanding of who are their shareholders so that they can interact with one another. The action plan also had to do with engaging shareholders. The idea was shareholders should take an active move towards their listed companies, and they should try to monitor listed companies in a way which will favor long-term performance of companies. The third topic of the action plan was about enhancing cross-border operations within EU company, which is really at the heart of what EU company law should be, in my opinion. Not limited to this, but at least this is absolutely non-discussable. This is obvious, they have to do something here. And then there was a small topic on codification of EU company law. Now, what are the main points from this action plan? First, there's a clear distinction between listed and non-listed companies. So, for listed companies, the EU focuses very much on shareholders, stakeholders, corporate social responsibility. But the EU legislator, the Commission, also deals with non-listed companies, and in this area, they are more concerned about cross-border issues. So for listed companies, the Commission comes with ideas which are substantive, basically, but which have to do with corporate social responsibility, and with non-listed companies, the Commission comes more with issues which have to do with cross-border elements. So these are really two different fields, basically. The action plan was essentially an evolution, not a revolution. So it's something which is really following a trend. It was not overly ambitious, but still it's something very useful if it's applied. The reflection group on the future of EU company law made an answer to this action plan, which you can find in the European Company and Financial Law Review, called ECFR, which actually just behind me. It's the orange we run a law review, which is behind there, and you can find there the article. It's published by Digrita. Okay, now let's make the presentation with these two parts, listed companies and non-listed companies. For listed companies, two issues were really have been tackled by the Commission. One is about how to improve corporate governance, and the other one is about corporate social responsibilities. So let's start with corporate governance. One proposal which has been published by the Commission in 2013, in April, was a new directive which will force companies, listed companies, to disclose in their non-financial statements information relating to environmental risk, social risk, employee matters, human rights, anti-corruption. So this has to do with reducing the level of risk for listed companies. This idea comes from the fact that risk is not only for the financial sector, it also occurs in the non-financial sectors. Let's take one simple example. BP, British Petroleum, was subject to an oil spill, which was extremely costly for the company. And still the company is dragged down by this, the consequence of this oil spill, and therefore risk, non-financial risk, should be also taken into account in non-listed companies, listed companies, and also in companies which are not financial activity. So this type of regulation is about disclosure, but actually it's a kind of it's a substantive regulation in disguise, because if you have to say that you have no you do nothing about your risk, the risk in the company, it means it's just not accepted by the market. So you have to do something about this. Another point, where the Commission is modernizing EU company law, is corporate governance reporting. Corporate governance reporting, the problem here is that many companies are subject, well, listed companies are subject to comply or explain regarding corporate governance codes. Many codes are applied, but sometimes they are not applied in a way they should be. So people say, just pay lip service. Or sometimes they are not applied, but the reason for not applying it is not explained clearly. So this is something the Commission is trying to tackle, and whether we'll do by recommendation or directive is still to be seen. My guess it will be rather a recommendation. One other issue is better regulation of related party transactions. Related party transactions are transactions between the company and the management or major shareholders. They are, of course, subject to large conflict of interest, because two parties are just, in a sense, presenting the same side. So there have been a lot of abuse in many member states. The issue is whether this should be dealt at the national member state level or the EU level. So the EU might be coming with something, maybe in the Shareholders' Rights Directive, which will be, should be published in the first semester 2013, when the reform of the Shareholders' Rights Directive. Now next, there's also a technical issue about acting in concert. The Commission wants shareholders to monitor better management in view of long-term performance. However, there's a rule which is civil law rule on acting in concert. If people act in concert to influence a company, they might be subject to takeover. So of course, this has a chilling effect on companies and on shareholders who want to be active. So it's not something very good. How to fix this? Well, one way is to change the takeover directive, but the takeover directive is something, is a text which was so difficult to adopt in the first place that nobody wants to open it again. So another way is to try to go in a smooth way, and this was the path which has been used. So the Commission has asked the European Securities and Markets Authority to set up a working group on this, made up of national competent authorities on takeovers, and come with a report. This report was published in November 2013. You can find it on the ESMA website. And this report basically gives a list of what national competent authorities considers as actions which are not acting in concert and which therefore cannot trigger an obligation, a duty to launch a takeover. So this is a very good way to try to deal with the problem. Another issue which has been dealt for listed companies is transparency of participations. If someone wants to take control of a company, one way to do it without being noticed is to buy what is called cash-settled derivatives, CSDs. What is CSD? CSD is a contract with a bank by which you get the performance of a share without getting the share itself. However, due to technical reasons, which I will not develop here because it would be a bit too long, the bank buys the shares basically, and sometimes the owner of the contract has asked the bank to give him the shares, and therefore he becomes suddenly a very large shareholder in the company, and then this is very easy then to take control of the company. So it's a kind of loophole basically on the rules on crossing of thresholds. So this loophole has been closed now at the EU level because the Transparency II directive, the reform of the Transparency Directive, which was adopted in October 2013, has included these CSDs into the calculation of thresholds that you have to disclose. So it's no more possible, it will not be more possible at the EU level to try to take control of a company through the CSDs. Many member states already dealt with the issue, UK, France, Germany, Italy, so this is just one way basically of harmonization. Another issue is shareholder identification, because the Commission wants shareholders to work better with companies. It's important for companies to know their shareholders better. At the national level, it's very easy. Usually you can get access to who is your shareholder, even if there are bigger shares. Problem is, with large listed companies, many shareholders are abroad, and this chain is hard to break once you cross the border. So you need an EU rule. So this issue will be dealt with in the reform of the Shareholders' Rights Directive, which should be introduced in by the first semester 2013. One other issue, which was also in the reflection group, in the green papers, is about transparency of institutional investors' activity. The Commission wants to put some pressure on institutional investors to explain what they are doing with their participation in listed companies in order to try to influence them into helping companies to adopt a long-term view of the economy. This should also be dealt with in the Shareholders' Rights Directive. Proxy advisors, also covered. What are proxy advisors? Proxy advisors are firms, mostly US, some in Europe, who give advice to institutional investors about how to vote. So, for instance, you have participation in 3-4 companies in Europe, and you want to vote on all the resolutions at the shareholder meeting. Well, it's time-consuming, it's complex to know whether you want to vote yes, no, abstain. So this can be delegated. You can delegate this to companies which will give you advice. It's kind of rating agencies in a sense, but for voting. These proxy advisors are not regulated. It's something which is free activity, but some companies have complained that these proxy advisors firms are not serious enough, are not doing enough due diligence, so they give advice without really knowing what they're speaking about. I think this point is a bit overstated. It's mostly made by France and Italy. But however, the Commission has decided to tackle this, and it has been done in two ways. First one is the Commission has asked ESMA, the European Securities and Market Authority, to come with some proposals, and ESMA has basically asked the industry to come with a code on this. And second, the Commission might also come with some regulations in the reform of the Shareholders' Rights Directive. Now, the other point in which the Commission is moving in terms of EU company law is corporate social responsibility. So the first issue is management remuneration. The big topic is about whether companies should have a say, shareholders should have a say on pay, which means should they vote on management remuneration. people who are members of the board of directors, so including the CEO. This has developed a lot in Europe. You find this now in the UK, also in France, although it's self-regulation to a certain extent. So this has been developed very quickly in Europe, and the Commission will probably come with something on this issue. How it will look like, it's something which cannot be said at this stage, but probably it will look like what the United Kingdom has done in this era. So something rather soft, but still, it sends a strong message in case companies don't apply. Another issue is about policy and gender disclosure. So here you have two directives which have been proposed. One by the Internal Market Commissioner, Michel Barnier, which proposed that companies disclose basically what they do in terms of numbers or representation of women basically on boards of directors of listed companies. So this is a soft approach. Another approach has been introduced in another directive, which has been proposed by Viviane Reding, who is in charge of the judicial affairs at the Commission. And this one is more strong because it asks basically for quotas. Finally, some ideas which were aired in the Green Paper on long-term financing still have to find their way into the Shadows' Right Directive or any other text. So this is basically what you can expect into at the EU level, with one more point, which is the reform of the Transparency Directive. So this reform was adopted in October 2013. You have to disclose payments made to governments in the extractive industry for listed companies. So this is a way to deal with corruption, basically, in countries usually outside Europe. So this also has to do with corporate social responsibility. So CSR, as it's known, at the EU level will be dealt with in basically three areas. You have say on pay, so management remuneration. You have quota agendas, and then anti-corruption practices. Now this is the end of the first part. Now let's look at the second part of this presentation, which deals with non-listed companies, which is a totally different world, because these are smaller companies. If you take non-listed companies, you have to see that at the EU level, the Commission is moving basically only where there is a cross-border issue. Either it's a direct cross-border issue, either it's an indirect cross-border issue. But in all cases, it has to do with cross-border issues. The Commission is basically shy, doesn't want to get into substantive harmonization of issues which are which are purely national. So it's a cautious approach by the Commission here, because member states will not accept, basically, if it doesn't have a strong cross-border element in the proposal. First point, what is direct cross-border issues? Well, the first point is the project of 14th directive on cross-border transfer of seat. This has been, I won't say a nightmare, but it's like an issue which pops up and down all the time. There's a very strong support of the Commission to come with a proposal to make it easier for companies to change seat across borders. So to move from France to Italy, France to Germany, Germany to the UK, and so on. A lot of support by the industry. However, this was also proposed by the reflection group. However, the Commission has decided not to move in this direction for three reasons. Member states are against this in this current environment because they fear to lose the tax base. However, this has usually nothing to do because the tax base is where the plant is, where you have the offices. It's not where you have the legal seat. So this should be tax neutral, but still there's always the risk that the fear that you are going to lose tax base if it's too easy to move across Europe. Second issue, like for VSP, is the issue of co-determination. If you change your seat from Germany, where you have a strong worker participation system, to France or to Italy, you are going to lose, you might lose worker participation, and therefore this is something considered to be not acceptable. And then there is this opposition between member states, which makes it not a very good environment to work on this. What will be done, however, this was a proposal by the reflection group, are some technical fixes on the cross-border directive. Now, indirect cross-border issues. Well, first one, you have the Societas Europea and the SP. The Societas Europea, or the SE, is a large type of company which can be set up and can change its seat from one country to the other. So it's a company which has its legal personality through the European legislator, not through national legislator. The SE so far has been a mixed success, not to say actually even a kind of failure, because it has not been used by many countries, many companies in many countries. It has been used in some countries, but basically it's not up to what was expected at the start. So it's not a great success. The Commission is planning to do some advertisement to make this firm better known. As to the SP, Societas Privata Europea, this project so far is not going to move forward. In October 2013, the Commission announced that it will not carry on this project because this SP project is very close to transfer of seat. So these two issues are related. If you have an EU company form, you can move your seat very easily. The SC is not such an issue for the Commission and for the member state because the SC is very costly to create. So therefore, it's not accessible to everybody. So the risk of moving company cross-border is limited for member states. Now there's a very interesting project by the Commission, which I hope will be proposed. This is the single member company status, the SMC. The SMC was proposed by the Reflection Group report and is one way to harmonize, but to a limited extent, what are limited companies in Europe, so SRL in Italy, SRL in France, GmbH in Germany, and this would provide for some limited harmonization, which would make it easier for someone in one country to create a subsidiary in the other country. So harmonization will be limited to a few technical points, which will make it easier for someone in one country to create a sub, for instance, in Cyprus. The national member state in Italy, in Cyprus, in France, will still keep its usual SRL GmbH limited or type of company, but they will have a sub-form which will be somewhat harmonized at the EU level. And this will, that's the hope of the Reflection Group, also the Commission, this will help companies to expand cross-border, especially small companies. So companies who cannot pay for a lawyer to discover what are the rules in Italy, in France, and Germany. Because the rules are very different from one country to the other. So this will be a very useful project. I think it's a project which has a lot of support in the member state because there's been a lot of reforms of the SRL limited and GmbH type in Europe recently. Interest of the group as the last point that the Commission might want to deal into. There was a proposal in the report of the Reflection Group to have a recognition at the EU level. I personally think this would be also very useful at the EU level. When it comes to recommendation or directive, I think it could be a recommendation, but this is something the Commission will not deal immediately. It's something which I think will be dealt in the second part of 2014. So to conclude on this modernization of EU company law, we can say basically 4 points. So first point, you have technical and political measures at the EU level. Corporate social responsibility being clearly a political issue. Then, second point, at the EU level in company law, you have soft measures, disclosure, ESMA public statement, acting in concert, and you have some substantive harmonization or regulation, but which is very much targeted at few technical points. Third point, you see in this movement of the EU Commission in this era a lot of influence of the financial crisis. So risk management, this comes from the financial institutions. And my last point on this presentation on modernization of the EU company law framework would be to say that the action plan, which was published in December 2012, is something which really is achievable by the Commission, which will be very useful. It's not overambitious. As I said, it's not a revolution, but it's a nice evolution, and I think would be very positive that all the measures which are included there will be implemented. And I think they will be implemented in 2014, some were already implemented in 2013, and in the coming, maybe even 2015. And this will be something which will be very useful for the EU level. I thank you for your attention. I hope you enjoyed this presentation, and I hope to see you maybe one day in person. Goodbye.